The bill to the House.
The question is that the motion be agreed to.
Speaker.
Charles Cheval.
Thank you, Mr Speaker. Mr Speaker, we've heard from the Minister that this bill arises from an exercise that was begun by the Law Commission, I think actually in October 2006, and only completed in August last year. So something that took over 5 years and was required to be done in 4 different stages because of the scale of the work. And I read the report again today. It contains some sweeping recommendations for reform, and this is really no less than we should expect. After all, the original Act dates from 1993, long before social media were in any vogue, before smartphones, even before the widespread use actually of the internet and email. So reform is overdue. The way in which we deal with information in our society today is vastly different to the way it was in 1993. And the Law Commission recognises this in its full report. Some of its recommendations are that the Privacy Commissioner's powers should be significantly augmented by a new power to issue a compliance notice where there is a clear breach of privacy principles and where there's a good reason for it to require an audit of an agency's information handling procedures. And all we need to do in this House is think about some of the recent controversies around organisations like Google, to think about what an important addition to the Privacy Commissioner's armoury and what a useful one that would be from a consumer protection point of view that would be. The Commission also recommends that the complaints process under the Act should be streamlined in a number of respects, including giving the Privacy Commissioner a binding power of decision on complaints about people's rights to access to their own information. And anyone who has been involved in supporting a complaint to the Privacy Commissioner knows that the current procedures are tiresome, cumbersome, they take a long time, and in the end the Commissioner herself doesn't have a power of decision. All she can do in the event of failing to get the parties to a complaint to agree is to refer the matter on to the Director of Human Rights Proceedings, who can then decide whether or not to take a case to the Human Rights Tribunal. And he may not, in which case the only recourse to the complainant is to fund one him or herself. So that clearly is something that needs reformed. There's another 3 significant recommendations that I want to mention tonight, sir. Agencies should be required to notify people when personal information held by an agency is lost or otherwise compromised, for example through computer hacking, if the breach is sufficiently serious. There's just nothing in the Act or the privacy principles at the moment to equate with that sort of requirement, and it's obvious why. 1993 predated hacking. There should be, this is another recommendation, sir, a new framework in the Act to allow the sharing of personal information between government agencies where it's in the public interest to do so, but with appropriate safeguards. And finally, some exceptions to the privacy principle should be modified. For example, to clarify that people can pass on information to an appropriate person where someone's health is seriously at risk or report suspected offending to the police. And it'll be apparent, sir, from the Minister's speech and from any reading of the bill that it's just those last 2 recommendations that are being picked up and dealt with in this legislation. Now, last year, the government identified information sharing in particular as a matter of urgency. The Minister mentioned in her speech that she thought first there were difficulties around information sharing in the government sector, although she didn't specify what those difficulties were. And she mentioned the problem of child abuse. But again, I'm not sure, with respect to her, that she made a link between that undoubtedly very troublesome phenomenon and the amendments that are proposed in the legislation that we're looking at tonight. Nonetheless, it's clear that the bill is being brought forward to progress those last two recommendations of the Commission that I mentioned, and we've heard that that is the rationale for it from the Minister. So that's the basis on which we need to evaluate this legislation. Sir, on this side of the House, our usual practice is to support legislation to a select committee unless the proposals that are contained in it are repugnant or just fatally flawed in some way. And as I've said, these are proposals that flow out of a carefully considered Law Commission report. There are significant safeguards contained in the information sharing powers. And so it seems to us that because the work flows out of recommendations of the Law Commission, we should not at this stage fail to give it our support to go to a select committee to be properly considered. The information sharing regime that the government will be subject to under the bill clearly is intended to improve clarity, to ensure that information can be shared with more certainty, and make it easier for that sharing to be carried out, as I said earlier, with appropriate protections. Obviously, any increase in government control over New Zealanders' personal information needs to be carefully considered and balanced with strong safeguards. But it is apparent that the bill, consistent with the Law Commission's recommendations, does contain those safeguards. It provides for transparency, accountability and robust decision-making in the sharing of information by setting out the considerations that must be taken into account before information is shared, including the privacy risks. It requires transparency around this decision-making by giving the Privacy Commissioner the right to publish her advice to ministers, and I hope that it becomes a regular practice that that advice simply will be tabled in public as a matter of course. There are requirements on departments to report on their activities, and information sharing agreements that are reached are always subject to review by the Office of the Privacy Commissioner. Obviously, there's also the fact that any resulting agreements will be treated as delegated legislation and they'll be subject to the scrutiny of this House via the Regulations Review Committee, and I can assure the House as chair of that committee that we will take a robust approach to scrutiny in respect of these agreements. I think also importantly, the Law Commission has recommended, and the bill has carried this through into the first draft, a strong role for the Privacy Commissioner, including providing flexibility for her to vary requirements, for example on reporting, in accordance with perceived privacy risk. And she is the expert on privacy risk. It is appropriate that she should make that assessment. Now, sir, having said all that, I'm not left without concerns about this legislation. As I said earlier, I feel there's been an inadequate explanation from the Minister for severing these two recommendations of the Law Commission from the bulk of the rest of its work. And we are going to have a better explanation, frankly, at the Select Committee if support is to continue to be forthcoming. We are going to have to see the evidence for the link between the problem and the solutions proposed, such that they are sufficiently urgent to be brought forward in this way. There's the obvious danger, sir, that the rest of the Law Commission's work will just languish, given that this government does tend, in the area of justice and law and order, to accord priority politically rather than according to evidential need. And this would be a tragedy from a consumer protection point of view because of the enormously complex environment caused by new technologies that I referred to earlier. We especially need those enhanced powers on the part of the Privacy Commissioner, sir. And if the government's agenda is to simply advance these two recommendations and to leave all the others languishing on the order paper or not even legislated for years, then an absolute disservice will be being done to every consumer in this country by the Minister. I'm also concerned, sir, that the robust controls and safeguards in the bill as it stands might be weakened as we go through the process, and we'll be absolutely vigilant at Select Committee to ensure that that doesn't occur. And sir, there are some concerns in the regulatory impact statement that can't be ignored. It's noted that there are no resources provided for the Commissioner or for agencies to accommodate the requirements on them in the new legislation. So, Sir, we will be supporting the legislation to Select Committee. I wish the new chair of that committee well in our
Sorry to interrupt the honourable member.
but, Sir,
His time has expired.
I don't say that there aren't concerns that need to be dealt with.
Mr. Speaker.
To McIndoe.
Thank you, Mr. Speaker. Just before I begin, may I